Greetings, everyone. This is Abhivardhan from the Bharat Pacific. For some time, we have been doing interviews on public policy, geopolitics, and international relations. Since Bharat Pacific has been existent since 2018, the pursuit of this podcast platform was to discuss aspects related to law and public policy. We have had discussions on artificial intelligence and how it affects technological sovereignty. We have discussed Web3. We have discussed quantum tech. We have discussed much related issues of Internet of Things and how does it affect you know so today we have a very special guest, and we have been with the guest through the Global Law Assembly Conference and even Endocon. He is Mr. Ankit Sahni. He's an IP lawyer. I would call him an intellectual property expert, especially when it comes to disruptive technologies. So welcome to the Bharat Pacific, and definitely it's a pleasure to have you.
The pleasure is mine, Abhivardhan. Every time we take this platform, we take this stage, is such a nice feeling to be interacting and engaging thoughts and perspectives with you. And I look forward to doing that in today's conversation as well.
Indeed. So today we have an interesting topic. We are going to discuss ChatGPT and intellectual property law. Now, I think everybody in the Janmanas, in the milieu, is available. Known of ChatGPT. People know what is ChatGPT. It's a generative AI platform which responds to your questions and suggests certain responses and answers. Scientists claim that ChatGPT does not understand or learn that way. It's just based on predictive analytics in certain ways, that it just takes up questions and then therefore it analyzes what is based on the data which is available up to 2021, because beyond 2021 ChatGPT doesn't know anything. In fact, the hilarious part is that ChatGPT is also subject to subscriptions, but OpenAI has claimed that ChatGPT, which is GPT-3 version 3, it's actually under free research preview. So that's a very interesting thing. So let's understand from your side. Uh, do you really think that ChatGPT is a legally viable, I would not say product for now, but a legally viable thing as it exists? What do you think about it?
I think to get off the mark, Abhivardhan, there are a number of challenges, but that has always been the case. When it comes to emerging technology and law, it is always the case of the cart being put before the horse, because technology develops and then law is always slow to catch up. So, if you could put it in the simplest terms possible, ChatGPT and inventions like ChatGPT today exist largely in what is called a regulatory or legal vacuum. There's no law directly governing or regulating the operation of or human interaction or intervention, etc., interfacing uh, of how ChatGPT functions. And the issues are very broad based. I would put, if I were given a chance to plot it on a map, I would put it in all directions, 360 degrees, and right from data and privacy being one, intellectual property being another one, liability and consequences being another one, the ability to utilize somebody's data without having to compensate them or against their will, etc., being one. Then uh, other aspects regarding licensing of this to users, on what terms it is licensed, how is the end product to be seen or utilized, and then a whole spectrum of issues. Therefore, as far as viability is concerned, I think only time will tell how countries decide to develop policy eventually, the legislative framework, whether it will be a movement akin to, say, how intellectual property rights developed eventually with TRIPS and several other international conventions being agreed, and then countries agreeing to amend their respective domestic laws or to bring about new laws in compliance with what was agreed at that level, or will it be more organic, with each country deciding as a sovereign as to what their approach to regulating AI will be, and then at some stage later on, maybe countries agree to sit together across a table and try to harmonize their practices. So this, in my view, is what the landscape looks like at the moment.
That's an interesting way to start the talk. So, I have observed for a matter of fact that in 2022 there was a UNESCO recommendation on the ethics of AI. We had analyzed it for ISAIL as well, and I had written an article for Analytics India magazine in which what I tried to say was that right now there would be no treaty or no such kind of a big legal document coming up, because see, the problem is, even if we analyze the European Union AI law, the AI Act, it's a it's a law which is very I would say very sophisticated. There's an annex 1 which defines AI, and there are three ways to define AI. It's too specific, it's very anti-market, because see, the problem with even the AI industry is, I mean, the so-called AI players, we talk about OpenAI, and now Microsoft has acquired them. Even others on using even recommendation media like Twitter or anyone, these are big tech companies, and even OpenAI is in the big tech. I mean, we can't just deny that from a fiduciary perspective. So what happens is that there was some news that Elon Musk, Bill Gates, Sam Altman, all these people, they actually said that there should be a moratorium on creating any AI technology, which I called as narrow AI. It's not even AGI, because we don't even understand AGI. And I'll get on the legal research side of it afterwards. What's the scholarship status right now? But I think that this moratorium, that, you know what, so they developed ChatGPT, then they developed GPT-4, and when GPT-4 happened, the hilarious part of this is that they are actually saying in this petition under Bill Gates, Elon Musk, all of this, that you can't develop any GPT beyond GPT-4, which is like GPT-5, 6, 7, because their concern is, number one, uh, it might not be workable, it is not safe, there's no understanding of this. And number two, what is understandable from this is that again these the concerns are big companies doing anything anywhere. So that's definitely a thing. So what do you think about it?
No, I understand in terms of the thoughts that some of such people like Elon Musk and others have voiced regarding the pace at which AI, especially since ChatGPT went mainstream, the pace at which AI is developing, and again the pace at which legislation or regulation is trying to catch up. So there is definitely a mismatch. And as regards which one of the two is going to win the race, it seems that the answer is very clear. The speed at which technology is evolving, it is perhaps proving to be too quick for countries to realize. A lot of it probably accelerated because of the pandemic, and some things remained under covers. Things emerged, like they say, necessity is the mother of invention, and perhaps things accelerated in that time frame when the world thought things had paused and everybody was trying to understand what's happening around them. People were, and probably researchers and scientists, data scientists and others, were sitting in their offices or homes, continuing research with far more time and resources available to them than before, and also this ability to be able to connect remotely. Of course, none of the technology that we use is remarkably new, but everybody just realized that this was a much more efficient way to connect and be able to continue work. So I think all of this taken together, technologies evolved very quickly, and the challenges seem to be several, because right now the mode and manner in which we access something like ChatGPT, it's still largely limited to a text-based prompt which is available as a cloud-based service on your browser or on your mobile phone as an application, etc. But now the real game is about to begin, or has just begun, when they start offering this service as an API and it starts integrating into other applications. That is when the cat will go out of the bag. Now, something as primitive or as simple as, for instance, allowing Google Mail, Gmail, and ChatGPT to be connected through an API. See, that itself, uh, fundamentally, if you see it in isolation, is not that big a deal. It's your regular private, in most cases, private email inbox. getting connected through a tool which is at the moment largely being seen as something that can be a very efficient assistant, almost as able as somebody's human personal assistant, if not more. But the idea is with this small step as well, if at all. And this is not to criticize or to say that this is incorrect or correct, but only to see the magnitude of impact that something like this may have, is that the moment this fits into your inbox and it gets access, there are privacy concerns arising out of it, because you don't know what kind of conversations it may read. In fact, it may read all of it because it has the ability, and it is by design created to process large amounts of data and to be able to make sense. So the question is, in terms of, for instance, one answer could be in terms of compartmentalization in ChatGPT's learning. Where is it when we move from its use as a text-based prompt to plugging into through API form into a person's inbox or other applications? Where is the literature on or white paper on from OpenAI or anybody else, whoever may please to write on this aspect of compartmentalization of data? How is the solution, the algorithms ensuring that what it is learning from one person's data, it is not reproducing in another person's prompts and answering queries based on its learnings through something else? Where is the regulation? What are the benchmarks today, if at all there are any? Of course, there are several private organizations, we've read about them. There are various names which you don't need to take. Everybody is aware. But they have developed all sorts of frameworks, arguably. And they say, look, our framework is so far the most efficient one that exists in this vacuum. And we believe it could be a good starting point for people to audit algorithms or audit how a particular AI program is trained on data sets, and whether or not it is ensuring compatibility with existing data protection best practices or any country's laws, etc. So and once you link it, like I said, the cat is out of the bag, and then it's too late, because this is already happening. There's nothing stopping it, and the use cases will only keep increasing. And eventually, everything and anything, we've had instances you've seen where class action suits have been filed against several generative text and generative art programs, where artists have said, look, here is evidence of the fact that this doesn't do. It's just a sophisticated copyist or a copy editor, which is mishmashing different pieces of work and presenting to you what it claims or what you understand to be an original artistic work or whatever it may be. But here are some watermarks or signatures of our original work, which are visibly or perceptibly present in the final output, which makes it very clear that this is nothing but sophisticated copying that it is doing. So I'll pause here and maybe hear your thoughts on this.
Yeah, so there was actually an issue on Reddit. On Reddit, somebody posted that their painting, it was an anime painting of some dragon warrior or something, and it was said that you can't just have, or something like that, some moon warrior or something like that. You just, and what Reddit did was, the platform said, we will just remove it because it violates the community standards. The reason for violation, according to Reddit, was okay, copyright law violation, because an AI company claimed that okay, we created this generative art. Now, like you rightly said, I mean, signatures, QR code, name, or any other symbol which shows an artistic approach to work. Because I'll tell you, for a matter of fact, let us say a background score is produced, like Hans Zimmer produces it, Michael Giacchino produces it, or Ravi Basroor or Raja produces it. What happens in the music industry is that whenever Americans or Europeans or outsiders, in India, I don't know how it works, because with Bollywood, Hindi cinema, it's a different problem. Because I don't think in India anyone releases BGM that much, except the southern industry. The Bollywood doesn't do it. So let's say in America, Marvel Studios or DC came up with their own soundtracks. So what people do is they create their rip-offs, their own version of Batman theme, Superman theme, Iron Man theme. Okay, so what they do is they say, fine, we are obviously creating our own version, but then at certain timestamp they actually put certain things, certain vocal instruments, certain vocal instruments, they're not doing a copyright violation. It's like a cover of a song. You get it, right? So it's their own version of what they conceive of. Similar happens in art, wherein people create paintings like knockoffs in a way that, you know what, we are inspired by this, but it doesn't mean that it is an art clearly, because in art law, I don't think it applies. So the problem with such generative applications in art is that when you use them, uh, my only question is, like you said, compartmentalization of data quality, data portability is there. Beyond that, how algorithm is even analyzing it, and first and second of all, how are you even ensuring that the algorithm is understood in a way that it is actually creating this? Because anything which is created, a written statement, anything which is a work of art, even performing arts, anything, it has a sense of human agency. So, without having a human element to have an intent or think, how can some company just say, there's something, I will not take the name of the company. They have this thing that you can't use it for commercial reason, but you can create AI based music, which is fine. I mean, it's great. You can use it for personal or what purposes. My only issue is they might do it, and there's nothing criminal in this. I mean, they might have to pay some licensing fee, but again, how is it doing it? Is it able to explain the stakeholders from what data it is taking? There's a case which you might be aware of, which is related to GitHub. So Microsoft acquired GitHub, and GitHub violated a very simple aspect of copyright law. What they did, and I think it's a violation that it's still pending in the court. So what they did was that, um, I don't wish to comment on the procedure. I'll just say that, so GitHub has a lot of code, right? Java, Python, and all those, right? Backend code and API codes. Now, what if the company thinks one day that, you know what, we'll use machine learning, we'll analyze all the codes that is available globally because developers rely on GitHub, and we'll just use that data or as of a training data to recommend people to write codes using AI. And the problem is, by whose permission? Because I don't think under copyright also properly you can recognize a code that way, but there are rights, obviously. I mean, we give licensing rights in coding also, if somebody uses an API or something like that, if it is paid or free. So, I think that's something which is a very interesting buffer zone in IP law to consider. So let's take something else, and I'll ask you this. Now, I tried using ChatGPT for fun, and there's an article which I've written for Visual Legal Analytica. It's available, like regulating and self-regulating ChatGPT. In that article, I actually put two instances for people. So there's a company in US which claims that in US you might be aware that even for petty civil law cases or divorce related issues, or even a normal application for restraint order or anything, the cost is just too much. It starts from 1200 US dollars to something like that, which is too much for a person. Even for petty commercial law issues which are within the scope of consumer law, the cost is too much, right? It's not just 500 USD or something, it's still too much considering the American economy. In India, it's different. It may start from 10K, 20K, you may know better. The company claimed, okay, fine, for these petty things, for drafting, Chat GPT will help you. We have an API which will work, and so forth. But and I think they are being sued in the US right now. I think imaginably. I don't know if it's true, but I heard that it is happening. So um, the problem was that when I tried ChatGPT, I asked two questions. First, I said, draft an arbitration application to a bench in the Delhi High Court. So they actually so ChatGPT had data of Allahabad High Court, Delhi High Court documents, and all those High Court documents. They analyzed an arbitration petition template, and they created their template. You can have a look at it. I mean, you can verify if it is even fine. And then I made a complicated request. I said, you know what, draft a request under the Income Tax Act to the Income Tax Appellate Tribunal under a particular section of the Income Tax Act. I did it on purpose to check how ChatGPT interprets. And I can tell you, it's like just a lackluster affidavit draft. Like, making an affidavit is not a big deal. It's still very simple to do so, except if you are not good in legal language. So, so I think when it is claimed that Chat GPT can replace contract drafting, aspects of legal interpretation, do you really think that there's some weight to this point? Because I think it might be good for consultative reasons, for just understanding, but I think specialists will always win. They will also always come up. So what do you think about it?
No, I definitely think that technology cannot replace humans, fundamentally speaking. and at least not for the foreseeable future, while you and I, you know, will probably remain on this planet and probably another couple of generations after us. I don't personally think that technology will ever make a human being redundant, right? But having said that, I think the capability and the sophistication of how well technologies like ChatGPT will be able to render, I think it may not be in our best interest to underestimate. Of course, at the moment, the way it exists could be uh, uh, because of a number of reasons. One of the reasons could be that it has not yet been trained on specialized data pertaining to the legal field. So if they create a variant of ChatGPT which is trained extensively on the same amount of or volume of data uh, as it has been in a general sense over the internet, etc., uh, and train it on that volume of data for legal work, perhaps its ability to be able to draft some of those things, like an arbitration reference to arbitration application, section 11, or an income tax appeal, or whatever it is, with much more accuracy and with probably more, it'll make more sense than what it does in some of the prompts that you did. Similarly, I tried putting in my own prompts. Of course, it does appear to be, if we were to personify it, which is wrong, but imagine it as a person really drafting it, it would appear to be coming from a person who's had a very 5,000 feet, perspective about law in these aspects. And then if you tell him to draft something, at max, he'll take some days, Google, and produce something. It was that level of output. But perhaps with the more specialized data set, it could, a linguistic natural language learning kind of tool, the capability that it has, it might end up surprising all of us. That's one. The other is that perhaps the tool as it exists today has been designed keeping in mind the kind of conversation that it has today to assist people in day-to-day things. One of the things that I prompted it were, okay, I'm traveling to Spain in April. Can you prepare me 3-day itinerary of things to see in Barcelona? Please bear in mind, I've been over the past couple of months been reading various articles that people have written in perspectives. People who are calling themselves now professional prompters of Chat GPT and DALI and Midjourney, these kind of generative systems. They're coming
Yes.
out with to-dos around what should your prompt be, and how to subjectify it or objectify it rather than making it very subjective, etc. So one of the things that I picked up since then is to be more detailed. So I tried my hand and I said, look, develop a minute to minute agenda for me. But bear in mind that I will only be free each of those 3 days after 4 p.m. and I will have time till 9 p.m. So then, surprisingly, at least to my surprise, it showed certain suggestions which were one relevant for that time of the day. It excluded certain obvious sightseeing places, and in the beginning I was skeptical and I said, look, this hasn't been properly trained, as is the case with other prompts that people are giving it, right? Because I've already been to Barcelona and I know those things should have been on the top of the list. But then something in me told me, okay, let me just verify, is there a reason why ChatGPT has excluded it? So that particular place, when I entered their website and I saw the closing hours, that thing was closing at, let's say, 3:45 every Wednesday or whatever. And one of the days that I had said was, I'm traveling from May 15 to May so and so, or whatever, April to April so and so, 2023. So it has the ability to calculate, even if it is learned on or trained on data till 2021, ability to calculate, no difficulty, what days will be what dates, simple thing, right? So it told me, and which is probably why it excluded that essential place which anyone would put in their trip to Barcelona, because I said after 4 p.m. I'm free. And one of the days or 3 of the days were when that thing would be closed after, say, 3:45, 3:30 p.m. Right. So this is how amazed I was at how well it has been trained. But This is a question that only people who have created it perhaps or done more research on it can answer, as to how capable it is as a language, pure language based or communication based engine, to be able to read, learn from legal arguments, the way legal arguments are constructed or pleadings are constructed, and to be able to understand that pattern and then reproduce it in a fresh draft, given a fresh set of facts and you know points. So that I think we'll only come to know with time. But I would personally play safe by assuming that in the times to come, if not chat gpt, then some other solution is likely going to be that sophisticated that it'll have that kind of output. And as someone who I know put it very well, they said, look, humans don't need to be afraid of technology replacing them. They need to be afraid of not moving up the value chain. If you don't move up the value chain and in your day-to-day skill set embrace how to effectively use these tools. It's almost like saying that you go to law school and you don't know how to communicate over emails, or you don't know how to send calendar invites, then you're at a disadvantage. Of course, it's like comparing apples and oranges, but just to speak, if you're practicing law, practically, if you don't know how to compose an email or send a calendar invite, you can't practice. It's in the same manner, these kind of skills of embracing such technology, generative AI, should be taught in professional courses. Because if not for the entire duration, then at least in a semester or in internships, etc., so that people, students who are graduating, they're up to date with the best of tools and things that exist out there for everyone to take benefit from. So these are my thoughts on this.
No, the instance of creating an itinerary is very interesting that you mentioned. I think when it comes to generative AI like ChatGPT, to its merit, there are certain things which it does very interestingly, like paraphrasing and some things, but it doesn't mean that it is very perfect. I think, as you said, and as I was trying to say, I think we agree that people who are specialists on the domain of question, like it could be anything, family planning, or I don't know, medical science, law, it could be anything, and we say fine, or wedding planning, travel planning, or anything. If we understand to the extent of error that some software like this would do, at least we can be self-aware to make decisions accordingly. At least we got a second opinion technologically. That's the best way anyone could use. Even I use ChatGPT for fun reasons. I don't take it seriously. It sometimes is helpful in certain aspects, but definitely I don't claim that ChatGPT is perfect. But I think it's experimental. That's why I think it says free research preview all the time. So definitely, I mean, that's an interesting instance to look forward to. So let's move forward and let's discuss something about the commerce of generative AI. So recently, investors from Sequoia and others have actually, put down a lot of money on Web3 technologies and now generative AI. And now what happened was that despite the fact that India has recognized virtual digital assets still in a restrictive manner, which is perfectly okay with the line of the government's view on national security, because we know that, in coordination with Binance, it was known that Hawala transactions were being, used for using crypto. At least recognizing VDA, which is virtual digital asset in a limited sense under the Money Laundering Act, is fine. Now, what interested me was that the hype on Web3 tech is going down very severely, even on metaverse. While some companies like Shopify and others are using certain aspects of them into the Web2 frame, and then they're coming up with something else. They don't claim it Web3 yet, or they might claim it, but I still will call them Web2, because the problem with blockchain is not that you can't have a decentralized system, but the problem is blueprinting and all of those. And second, it's a very American idea. Everybody thinks in America that we can't trust the federal government or the White House and all those. Therefore, we should have a very separate currency. That's exactly what Balaji Srinivasan claimed, that one side of the political caucus should actually buy all the cryptocurrencies, and they should not rely on Bank of America and others, which is hilarious. It can't happen in India. We have direct benefit transfers, we have UPI. That's way better, even the CBDC. So why am I telling you this, and why I wish to ask you? So my question is that, let us say we are so what happened was that the hype towards Web3 is now shifting to hype towards generative AI. And I saw a trend like this company which I told you in America, which is building certain API tools and all that. There are many companies, and I've written an article on this on Visual Legal Analytica by the name of it's a complicated title, the Chat GPT and its derivatives, and derivatives of. So it's very simple. Chat GPT has a universal training data. Then it gets new inputs every time based on prompts. Obviously, people are prompting up. Then obviously it produces based on what it prompts. Obviously, in response, one can understand that you can use an API and create a derivative product. That's exactly what a derivative product could be. And the one problem which people could address is how proprietary information could be taken into commercialization. Because some may claim, if it is free research preview, why are you restricting in a certain fashion? Or why are you disrupting the market? Because then there could be certain issues on competition law which could come up. Right now, they might not be those mature issues, but I think that they might be, because MeitY and other ministries are interested in ChatGPT, and there's news happening. So, from a commerce point of view, from a product liability or product responsibility perspective, what do you think about generative AI products? Like, is there a scene that people are trying to achieve something better out of it? What do you think? Because this actually reminds more of corporate governance in certain ways and corporate ethics. So, what do you think?
No, I think this is really a very, very important point, and I'm so glad that you've brought it up. My views on responsibility is very simple. I think, the again, it's not obviously as simple as we like to put it, but I've come to realize in my interaction, in my engagement in this field, that if you start thinking, then there's no end to it, and then it keeps getting more complex. So we have to break it down into simplest of terms and have a starting point, then throw the idea open and then get more perspectives, and then keep changing it, altering it, to arrive at something which is much better in its eventual form than it was originally. So one way that I think this problem could be answered is, look, responsibility is at two levels. One is, if I prompt a generative AI tool like ChatGPT, if the output that it generates in any way influences me to do something to my property or to my person, and that ends up damaging my property or my person reversibly, irreversibly, or whatever it is, then there needs to be some kind of checks and balances that need to be put in. Because if the technology is capable enough for the technology to, based on my prompts, understand the context that I'm talking about and be able to produce relevant results without me expressly writing about what I want, then it is definitely smarter than other passive or yesteryear technologies, Web 2.0 kind of technologies, binary searches and all. Definitely much more capable of filtering out things which are potentially harmful or not useful, or whatever you may want to call it, for the society, right? So that there the responsibility should lie with the developers, or whoever is in charge of finally bringing that product from farm to table. The second level of responsibility is, if the generative AI gives me some output, and I utilize that output and present it to somebody else, and either it infringes somebody's rights, whatever it may be speech, blasphemy, etc. It may be seditious. It may drive somebody else to commit some kind of harm to their own person, body, or property, right? Then the person that eventually exercises the discretion to take that product of a generative AI and put it to some kind of use which causes harm to some other person, consequently, should bear responsibility. Is very similar to, I think, one of the earliest conversations that we had a couple of years ago. How at least I like to see it is, it's like a tree growing in my garden, right? Uh, if there's a tree growing in my garden, let's say it's an apple tree. Now the apples drop off, right? Some of the apples are rotten, some of the apples are fresh and they're nice and sweet. Now, eventually, I exercise as the person in whose garden, in whose property the tree grows. I exercise the discretion of choosing which apples to take to the farmer's market and sell. And as a result of consuming some rotten apples, if somebody falls sick, then eventually responsibility has to be mine. It cannot be of the trees, because the tree never said, okay, the tree said, okay, here are 10 apples, you do what you want to do with it. ChatGPT, in its present form of interaction, in a very Web 2.0 classic way of us putting a text prompt and it's just displaying the answer on a very two-dimensional browser window, right? Is not really, cannot be said to be guilty of influencing us or conjuring us or alluring us into utilizing it for one purpose or the other, which is where I think more immersive technologies will have a role to play. And depending on how it is presented, the output, especially visual generative AIs that have visual or audio based output, then it will be different. But here, if it's being presented like that, eventually I'm the one exercising discretion as to how it is to be used. And eventually, if it infringes someone's rights, I should be responsible. So the current state at which we are at, I think in the short term, this appears to be a very viable way of fixing liability. And as far as me getting harmed as a consequence of some results that uh, directly harmed as a consequence of some results that or output that the generative AI produces, there I think some kind of responsibility matrix has to be affixed on the developers, because they can't say, see, you've seen also a shift from intermediary liability, or rather safe harbor, to intermediary liability. Why there's been a shift is because from DMCA days, early days, 2000, 2001 to 2023, courts and governments have realized that technologies have evolved so much that companies are actually without the requirement of active human intervention, which was the main argument at that point in time, that it's humanly impossible if you're manning or running a solution like YouTube, for instance, to know which content infringes whose copyright or whose rights, whatever it may be. But with the increased capability of technology and artificial intelligence being thrown into the formula, it appears increasingly easy for companies with very limited amount of resources being dedicated, not more than a small team of people who would simply be monitoring a tool, which in turn would be doing the dirty job of analyzing big data and coming up with possible red flags as to what could be taken down, right? So the thing is, somewhere that absolute defense to any liability has to be diluted. If a machine, again, back to that point, if a machine is capable of answering or understanding your context, right, and has evolved to natural language processing to that level, it is definitely capable of flagging such an issue in advance before it even decides to present it to you on the screen. So those are my broad views on responsibility.
Yeah, I think that's true. In fact, uh, for big tech, it could be a serious matter because they do these acquisitions. There are merger issues and so forth. Whatever they present in marketing. But for MSMEs and emerging startups which are funded by VCs and bootstrapped and both, I mean, I don't think it's a big issue for them because I think at least one thing is there that data quality is a self-regulatory concern also. It's not just that GDPR comes up and done, right? I mean, sometimes certain companies try to do data safeguards or try to make machine learning more understandable. And this was a concern which my friend Bogdan Grigorescu, you must have met him on, I think, yeah, you did. There was a panel. Yeah. So, yeah, we had it. And he actually said the same thing that with machine learning, the problem is it's only learning. How is it showing that it is understanding and explaining it? And that's where I think the next level comes up, which is explainable AI. That why is it that these applications are trying to, whether they're understanding things or not. So I think the concept of liability will change a lot. It won't be used in a very ferocious manner, like we say, fine, it's a environmental or tort liability or something like that. I don't think there will be AI torts happening. So that's definitely a thing to behold. Final question. This is a very different question, a bit of a more academic question, but I will ask for the sake of curiosity. You remember the Davos case for sure, right? What happened in Australia, and then obviously the recognition of that AI as the inventor was rejected. Now, my concern, and this is why I'm bringing generative AI now, and I'm not bringing Davos, is that I think the reason why I find AI and patent law interesting in this regard, as to recognizing this patentee and inventorship differently, is because it might not be accepted right now, but it could be considered an aspect of involving corporate governance into IP in a good way, bad way, howsoever it is. I mean, I'm not predicting it. I'm not saying that there's an element of malfeasance everywhere. It's not true. There's an aspect of innovation which sometimes is required, so you need some special intervention in law. So, in copyright, while these issues come up in art, music, and text-based content, what do you think the evolution of patent law when it comes to addressing legal implications of generative AI? What do you think? Like, how will patent law shape itself, and maybe trade secrets also? What do you think about that? Some views.
I think, see, technology is already capable of generating much of eventually what can be with some human intervention, as rather than the opposite, as people expected initially that it'll be primarily a human effort and machine will assist, etc. Today, certain machines are capable of, especially we've seen the claims pertaining to Dabas, for instance, of creating something which, with minimal human intervention, can be converted to invention over which patent rights can be claimed, right? And much of the input or value add that the human really does is to transform it from a mere shape or idea, etc. In that case, it was like a container, in the shape of a container, and the fact that it has serves multiple purposes, etc. And it improves several efficiencies. So the thing is that the machine somehow produced that image. Now that image, if presented to the regulator, now we are entering the human layer and the governance layer, because we live in a society, in a country that has a constitution, and then from the constitution flow other laws, etc. So when we enter that layer, we have to abide by the rules of that layer and that system, which is that for patent rights to be granted, one thing is to say that sovereign countries are capable of issuing letters patent or patent rights or whatever rights they may be. The other is that there is a prescribed manner in which you have to apply, go through the process, and only then you will get that recognition. Now, to be able to comply with the prescription, the prescribed part, you will necessarily perhaps need some amount of human intervention, at least the level at which generative AI exists today, as we know, publicly known. That a human being will have to make sense and to some extent argue in the abstract part, in the prior art part, and others, how this is different from existing prior art, what are the various features that they're claiming rights on, why they're claiming rights on those particular features, etc. And then also to use the illustration that AI may have generated, label it as is required by in patent applications and patent practice and procedure, and present it, right? Now, if you examine this question, okay, from a 10,000 feet perspective, forget that countries exist and that statutes exist, and because we've not had instances of machines creating something worthwhile without much human intervention, we never explored, and legislations were never made with the presumption that there will be anybody else except humans, right? And then the whole reason that eventually rights and obligations can only be human, because only humans can feel bad or feel good, can be corrected, right? Can be deterred, incentivized, and so on, right? Something which doesn't have feelings or is not sentient, etc., has no interest and is not even recognized. I mean, even animal rights, for instance, I'm saying beyond the bare permissive or bare most basic rights of letting an animal live and thrive on its own, and hunt and etc. Anything that an animal is creating, you're not allowing more humans who wish to help the animal. We saw in the monkey case, for instance. One way to interpret could have been, see, today we have reached a level of deeming fiction of jurisprudence, and I sometimes use this example. If you've read the book called Sapiens, in one of the chapters in Sapiens, The example that the author gives is, he says, look, fundamentally where we diverged from more primitive animals and we became, what we are, or the prelude to what we are today. Um, One of the things that stand out between us and all the other millions of species that exist is that we are able to create fiction. Everything around us, whether it is a society, a trust, an association, a court, a constitution, a government, all of these are a company. These are all fictions that we have created. None of this actually exists. What stops us from creating yet another fiction, which is whatever you want to call it an AI trust, or these courts in India have been known to create fiction for deities that people, right? So in that context, the point is, if what people give to deities as their religious offering, the courts have held the right of the deity to include those proceeds to be only utilized towards the deity's well-being, which is maintenance of the deity's inner sanctorum, then garbhagriha, and then renovation of parking, this that, limitation of how many salaries can be, or how much of profit can the trustees draw out, for what purpose, etc. All of these things, without the deity being in a position to express its will, correct, is very similar for animals. In fact, animals are still able to express their likes and dislikes and so on, depending on what kind of animal species you're talking about. But for a monkey, why can it not be that the monkey, for instance, I mean, I'm just giving this as an example, not necessarily applicable to monkeys, but I'm saying, in an ideal world, perhaps the idea would be that if a monkey is able to produce something, right, don't let a human being make millions out of a picture clicked by a monkey, because there would be millions of humans wanting to pay somebody who produces such a picture and creates, let's say, souvenirs out of it, t-shirts, mugs, etc. Right, that money there should be a legal fiction, for instance, that could be created, and the money, or part of the money that is collected, should be utilized towards that monkey's well-being, and somebody should be put in charge, whoever is willing to. There are many of us who are animal lovers, and we would be willing to exercise this responsibility in addition to our regular human responsibilities towards each other and other humans, right? So the point is, I'm just saying, trying to make a point, that same kind of deeming fiction can be created for an AI. What I believe is that with increase in amount of time and the sophisticated in technology, it will become very difficult for the existing IP law system or legal system to exist, because the amount of effort that it takes a human being to create the same thing, and a human being with the assistance of AI to create the same thing, will keep on becoming enormously disproportionate to each other, because it is only going to become quicker and quicker for people to be able to create things using technology. And for us, for somebody who's equally talented, let's say as an artist or a musician, to take as much amount of time to produce or write music and then record it as it would take him 100 years ago, right? So the thing is, what is the objective of law? This governments have to decide. Do you want to keep intellectual property laws and other economic laws in a way that you only want to incentivize human creation? If that is the case, then you will, if at all, you will allow for recognition of AI generated works, which you will eventually, because then that would mean that the people behind putting efforts behind creating generative AI technology, they are disincentivized if everything is in the public domain, right? So if you're going to put your weight behind skewing in favor of human creativity, you would continue to hold purely human created works at a higher pedestal than AI assistive or AI generative works, right? So you would keep them at a much lower pedestal, and that, I believe, is at least the short to medium term solution to how we have to create a balance between the advent of technology in our mainstream day to day use, and balance that out with humans who are genuinely talented. Otherwise, humans will simply keep losing interest. Now, another important aspect, if I may come in, since we were talking about this comes to my mind, is that a lot of people I read, a lot of scholars were writing on the lines that, this has sounded the death knell for creativity. Creativity, as you know, classic arts and innovation and skill and talent, as we know, will eventually taper out and end. This I don't agree with. The same thing was said in the early 90s when the personal computer came. And people said, people who paint on canvas using oil paint and take weeks to produce that, all that will be finished when Photoshop comes and so on and so forth, and people will be able to produce something of the same level. Fast forward 30 years, I don't think much has changed. The value of a painting is probably definitely as much, and the fact that it is originated from a human being, one can equally well discern in today's age as one could in 1993. The only thing that is added is there is more variety. People who, for instance, could not afford to pay for an original painting, especially that of a famous artist, don't need to leave their walls bare. They have the benefit of resorting to technology and using digital pieces of art, which may be, some may say, you know, equally attractive or creative as that, but it's to each his own, right? It's only making resources and creativity more accessible. But I don't see any aspect of music or musicians being driven out, because eventually we went from we went from recording in the studio using very basic microphones and equipment to the era of Fruity Loops and so on, to the era of now generative AI music. The musicians have not left. A musician or a music producer of Lakshmikant Pyarelal era probably had a different way of composing music, right? Writing down notes and writing down symphonies, composing symphonies, and then orchestrating them live, and then recording, and then editing, versus what music producers of today, some of the newer DJs and other music producers, have resorted to: generative music coupled with some remixes or cover versions, as you mentioned. There are still enough number of people who would love to listen to the Lakshmikant Pyarelal kind of music. Enough number of people, on the other hand, who would want to listen to the more new age technology assisted kind of music, right? Nothing fades in that sense. So these are my my views on this aspect.
Yeah. Just to add on your point on creativity, even I think that human creativity is not going to die, because there's one very commonsensical answer for this. And to add to your point, I think what happens is there's something called anthropomorphism of AI. If you're using any technology artifact which subjects to technology distancing, this is a theory in the sociology of technology, I think in the late 1990s in some paper, but I use this technical term for people to be curious and understanding. I think if somebody uses an effort, if they don't know sound engineering that much, it doesn't mean they can't produce it. They just might find a hack to do it. In fact, one of the most, I would not say advanced musical creations, but very simple, normal music creation is that song called Attention, which got viral in 2017. So if anyone would hear, they will think, oh, there are drums, there are so many instruments involved. Just hear the track. Charlie Puth, the singer, actually uses his sound, phonetic sounds, and then creates it and then modulates it. So I think human creativity has its own bounds. Legally, I don't think it's an issue of culture law that way. I think it would be more about like how one does and how one claims. And even there, I think based on your point, what I can understand, and even I have realized it in the past, that um, human actions will be commonly saturated in the market. The market will understand eventually how it actually works. In fact, this has been an experience of mine, which I will share maybe after this session. So, yeah, so I think it was a great talk with you, and I am really happy that we had it. We will discuss something else for sure in future. Meanwhile, let's see how this goes ahead. Uh, I think generative AI has an interesting future, and meanwhile, I think we may expect some better applications and services and products to come up, which will balance the market for good instead of just coming up as pseudo disruptions. So I think that will happen eventually, and then maybe some regulatory appeal could come up, which is to say that government might be, interested, that what, let's just start regulating it, or at least start with self-regulatory measures, which are just fine to just map out things. So, yeah, it was a pleasure to have you, and thank you so much for coming.
Thank you, Abhivardhan. It's always a pleasure. I'm looking forward to our next